Welcome to another episode on the Law Rapport, episode 9. Today I would like to speak about commonly used terms in criminal proceedings. And it dawned on me that in the previous 8 episodes or so, that I have consistently used a lot of legal language and legal jargon and terms, and that I should put them in context so that when they're used in subsequent episodes that they could be understood. Now, for the usual disclaimer, nothing that I say in this episode is legal advice. I'm not offering legal advice to anyone, and nothing should be taken or construed as legal advice. For legal advice, please contact a competent attorney of your choice. The first term that I would like to bring to your attention is the term adversarial. And it is often said, and you may often hear it being said, that we have an adversarial system of justice in the Turks and Caicos, or within the English jurisprudence. Now, adversarial or an adversarial system means that the prosecution or lawyers from the Office of the Director of Public Prosecution and the defense or defense lawyers will have opposing arguments, and they will argue in court about the facts, the evidence of witnesses, or legal issues before the judge or the jury, and hope that these differences of opinion, of law, will be resolved in their favor. And in that sense, there is an adversarial nature to the proceedings. You will also often hear the word accused being used frequently in criminal proceedings. An accused is a person accused or charged for committing a criminal offense or offenses, and the accused is also known as the defendant. Another common term is arrest, and this is a procedure where a person is taken into custody either on suspicion that he or she has committed an offense, or where there's evidence that he or she has committed an offense and they are to be charged for that criminal offense. Once that person is charged, they should be brought before a court as soon as practicable, but they may remain in police custody until granted bail, either by the police, which is known as police bail, or until they attend court to answer to the charge, and then they may be granted bail by the court. Another frequently used term is arraignment. This is where details of the charge. In some jurisdiction, you'll hear the indictment. In the Turks and Caicos, it is the information, and the substance or the details of the information is read out to the accused person when he appears in court, and the person will be asked by the judge or the magistrate to plead either guilty or not guilty. In the case of indictable offenses, when an accused person appears before the magistrate court, they are not required to enter a plea of guilty and not guilty, because in law the magistrate does not have jurisdiction to deal with indictable matters. However, that person will be required at a later stage to enter a plea of guilty and not guilty to the charge when he or she appears in the Supreme Court. The term that you will certainly hear in criminal proceeding is the term acquittal or acquit or acquitted. And this is when a magistrate or a judge in the case of a trial by a judge alone without a jury, or a jury in the case where there is a trial with a judge and a jury in the Supreme Court, finds a person not guilty of the offense for which he or she has been charged. Additionally, a person could be acquitted if a higher court, in this case the Court of Appeal, overturns or reverses a decision of a lower court upon appeal. There are also cases where a judge or a magistrate, upon his submission of no case to answer by the accused attorney, may find that the Crown has not established a prima facie case and the evidence adduced at trial. This is also referred to as a half-time submission. Another frequent legal term that you will hear in criminal proceedings is the term adjournment. And it's simply a break or a postponement of legal proceedings, either for part of a day or until another day or until sometime in the distant future. So we say that the matter is adjourned, or the matter is simply put off for another day. Another frequent term that you will hear is admissible or admissibility of evidence. And this is used to describe evidence that is allowed to be given in court because it is relevant to the proceedings, because it goes to the issues in dispute, and at the end of the trial it is taken into account in determining whether or not the accused person is innocent, guilty. Not all evidence is admissible, and if a judge finds or magistrate finds that the evidence is not admissible, then it will be excluded. Evidence that is not admissible is said to be inadmissible. Another frequent term that you will hear used in criminal proceedings is the term affidavit. And this is simply a statement which is signed and sworn to by a person before justice of peace or a notary public, acknowledging that the contents of that statement is true and correct to the best of their knowledge and belief. You will also hear the term affirmation, and this is a promise to tell the truth in court. When a witness enters the witness box to give evidence, they are asked either to take an oath or to affirm. And if they choose to affirm, then an affirmation is given, and it is as good as an oath. So this is used by persons who do not wish to swear on the Bible or other religious books. Another term that you will certainly hear in criminal proceedings or in any court proceedings, and most court proceedings, but especially in criminal proceedings, is the term allegation or allegations. And this is simply an assertion or assertions made by one or more parties in the proceedings that is still to be proven. You may hear the term alleged offender. In law, a person charged with a criminal offense is presumed to be innocent until proven guilty of that crime. And so the person is referred to as an alleged offender, an accused person, or a defendant. You may also hear the term antecedents. And what is this term? This is simply a person's criminal record or criminal history or background. So a person who is convicted of a criminal act, criminal offense, will have a criminal conviction, and so this could be relevant in future proceedings, for example, in an application for bail, or if the person is convicted of a subsequent offense, then this conviction, while it is not disclosed to the jury, will certainly be given to the judge or the magistrate if the person is found guilty and is to be sentenced, or where the issue is whether the person should be released on bail or held in custody pending hearing. Another frequently used term in criminal proceeding is the term appeal, and this is simply to take a case to a higher court in order to challenge the decision of a lower court. And a person who is dissatisfied with the decision of a lower court, either if they are convicted or they are sentenced, and they are dissatisfied with the conviction or the sentence, could appeal against the conviction, the sentence, or they could appeal against both. The person who appeals against a decision of a lower court is called an appellant. In the Turks and Caicos Islands, an appeal from a magistrate court decision is appealed to the Supreme Court. An appeal from a Supreme Court decision is appealed to the Court of Appeal, and an appeal from the Court of Appeal or from a decision from the Court of Appeal is appealed to the Privy Council in England, which is the Turks and Caicos Islands' final Court of Appeal. Another commonly used term in criminal proceedings is the term bail. In criminal proceedings, bail refers to the release of a person from legal custody, either on his own recognizance or with surety or sureties to turn up to court for their child. A person bail may be required to abide by certain conditions. This is usually referred to as conditional bail. Then there is the term, the balance of probability, and this term is used in criminal proceedings in limited circumstances, because the balance of probability is the test or the standard of proof usually used in civil proceedings, and it is where it is said that something is more likely than not to have occurred. However, in cases where there is what is called a reverse burden of proof, where statute or a common law defense may place what is known as an evidential burden on an accused or a defendant. And this evidential burden is a burden to adduce some evidence in support of the defense. The standard on which this evidence is judged is on a lower standard than that of the criminal standard. So the standard is that of a balance of probability. So in essence, the legal criminal burden of beyond reasonable doubt never shifts to the defendant, because the defendant is only required to produce evidence to be assessed on the civil standard. Another frequent term that you will hear is barrister. Who is a barrister? Is a lawyer or an attorney at law who mostly specializes in courtroom advocacy and litigation. In other jurisdictions, there are different branches. You will hear about barristers and solicitors, for example, in England and Wales, but for the purpose of this presentation, that is not relevant. You will hear the term the bar tableau. This is where the lawyers, both defense and prosecution counsel, sit or stand at the front of the court, where they address the judge, and from where they make their closing speeches to the jury. You will hear in criminal proceedings the term the bench. But what is the bench? The bench is the elevated seat at the front of the court where the judge or the magistrate usually sits. But alternatively, the term the bench may be used when referring to the judge or the magistrate sitting in a particular case, or as a collective term referring to a number of judges, including those sitting on the same case. For example, in the Court of Appeal, where 3 judges sit instead of 1, collectively they are referred to as the bench. Another commonly used phrase that you will hear in criminal proceedings is a bench warrant, and is simply a court-ordered warrant for the arrest for failure to attend court. So a witness or even a defendant may be required to attend court. Maybe he's summoned, he's bound over, he's notified as to the date for court, and he failed to show up or refuses to show up, and then a bench warrant is issued for his or her arrest. Another frequent term that you will hear is the term beyond reasonable doubt. Now, this is the test or the standard of proof used in criminal cases, that a defendant must be found guilty only if the prosecution has proven its case beyond reasonable doubt. Another frequent term may be breach. And what is a breach? It's a failure to comply with a court order. Maybe a bail condition. And in that case, if there is a breach of a court order or a failure to comply, then there is likely to be legal consequences. You may also hear the term or the phrase brief of evidence. It is a commonly used term, and this is the collection of statements from witnesses, police officers, ordinary witnesses, expert reports, medical reports, photographs, the bail papers, the charge sheet, and all this is handed over to the Office of the Director of Public Prosecution or the prosecutor with conduct of the case by the police or the investigating agency. At the conclusion of the investigation, this material is used to determine whether or not the person who is the subject of the investigation should be prosecuted or not. And then there is another term that is commonly used, maybe not with the same frequency in this jurisdiction as others, and that is brief. For example, in England, Wales, and other Commonwealth countries, the phrase refers to papers given to the barrister when they are instructed. And now we begin commonly used terms in criminal proceedings, beginning with C. And one of the terms that you will hear very frequently is the term charge. And what is that? It is the allegation that a person has committed a specific offense. Another term that you may hear is closed circuit television, and this is a provision that may be available to some witnesses, such as vulnerable witnesses or child witnesses, who could give evidence to the court from remote locations, and there may be a variety of reasons why this is done. For example, in the talks and cases under the Vulnerable Witness Ordinance, the court can give what is called special measures directions, where witnesses who are deemed to be vulnerable could give evidence without having to attend court in person and to face all the rigors and challenges of an in-person attendance. Then there is the term closed court. What is that? A courtroom that is closed to members of the public, and this could be because of the nature of the hearing. It may be involve children, it may be family matters, or when the court is sitting in its jurisdiction as a family court, or it may be a very sensitive matter and the public could be excluded, and then we say the court is closed. It's really closed for the public. In one hearing, part of that hearing could be closed hearing, and another part of the hearing could be open to the public. That is not unusual. Another commonly used term is committal hearing. Well, we no longer have committal hearing in the Turks and Caicos Islands. What we now have is what we call sufficiency or paper committal, and I will deal with that later on in the presentation, probably in another episode. But a committal hearing is where the magistrate would decide if there is enough evidence adduced by the prosecution in a committal hearing to commit the defendant to trial in the Supreme Court. Then another commonly used term is common law. And sometimes here it is said that the Turks and Caicos is a common law jurisdiction, or that we are under the common law, or common law versus statutory law, and so on. Well, common law is based on previous court decisions and customs as distinct from statutory law created by Parliament. Another commonly used word or phrase, a term that you must hear in criminal proceeding is the phrase, the word crime. And this is simply an illegal or unlawful act. One who breaks the law simply commits a crime. Then you will hear of the term contempt of court. This is an offense of being disobedient or disrespectful towards the court. Another commonly used term is criminal history or conviction sheet. And this is a record of offenses of which a person has been convicted. Then in criminal proceedings, you will hear about cross-examination. This is where the attorney for one party, maybe the prosecutor or the defense attorney, questions a witness who have testified in the proceedings in order to test the veracity of the witness's testimony, or to undermine the credibility of the witness, or to clear up some ambiguity in the witness's testimony. Then you will hear the term closing speech. This is simply an address to the jury by the prosecutor and the defense counsel at the close of the case. This comes at the end of the case before the judge sums the case up to the jury. Another commonly used term you will hear is the crown. In court, the prosecutor may be referred to as the crown, that is, representing the queen or the state. Then you may hear the term custody being used very often. A person is in custody either on remand at the prison, or he or she may be in police custody awaiting a hearing, or the person may be serving a sentence, and so that person will be in the custody of the state. Another term that you will hear commonly used in criminal proceeding is complainant. And this is a term used in court to refer to the victim of a crime. You may hear the term conference being used, and this is simply a meeting with a solicitor or barrister to discuss the case or to receive legal advice. So the defendant or the accused person meets with his attorney to discuss the case, to discuss strategy, to discuss the defense, etc. This is referred to as a conference. You will hear the term conviction being used commonly in criminal proceedings. A person accused of committing a criminal offense, if he is found guilty of that offense, then it is said that he has a conviction. You may also hear the word counsel being used very often. Counsel is a barrister acting for a person charged with a criminal offense, or the counsel acting on behalf of the Crown, in this case an attorney from the Office of the Director of Public Prosecutions. Same, you may hear the term counsel for the prosecution or counsel for the defense. It's just another term or another name for the prosecutor or the defense counsel. And you may hear the term court officer or court officers. And this is simply person or persons employed to assist with the operation of the court. The court officers are court officials, the registrar of the court, the clerk of the court, the police officer, the personal assistant to the judge or the magistrate, all are referred to as court officers. And now we come to the final commonly used term in criminal proceedings in this episode, and that is case management. The active management of the case by the trial judge is referred to as case management. And this may include the early identification of the real issues in the case, the early identification of the needs of witnesses, ensuring that evidence, whether disputed or not, is presented in the shortest and clearest way, discouraging delays, encouraging the participants to cooperate in the progression of the case, and this is encouraging cooperation between the defense attorney and the prosecutor, making use of technology. So in instances where a person may have certain challenges and they do not have to appear in court, technology could be used and they could give evidence remotely. The court must actively manage the case by giving any direction appropriate to the needs of the case as early as possible. And there are much more where case management is concerned. In fact, this could take an entire episode, but here is where I wish to leave it for today. Thank you for listening, and in the next episode we will continue with commonly used terms in criminal proceedings.